own relationship manager. That's the important point, its own relationship manager, for the purposes of conducting its business with the claimants. And I'll come to that shortly, but the evidence was that Bank Sarasin, that while of course Sarasin-Alpen might have a client relationship manager for its relationship, Bank Sarasin would have a client relationship manager for its own banking relationship. And the reality in this case, as the judge found, is that Bank Sarasin was using Alia and Nair as its relationship manager for its banking relationship. And that's exactly what the judge has found, and I'll take my lords to some of the detail. Because this goes to the heart of what was really happening here. And the provision of the relationship manager for Bank Sarasin was a key part of Bank Sarasin's provision of its investment services. And that was all done using Sarasin-Alpen personnel as Bank Sarasin's relationship manager. And they were conducting that relationship in and from DIFC. So, my lords, what I'm going to do in these submissions is first go through the judgment, then deal with some of the key underlying factual points which relate to the various heads of conducting investment business. Then I'll deal with my learned friend's grounds of appeal, starting with his more technical points on the rules, and then moving on to his other points on territoriality and jurisdiction, as they appear to be. So, my lord, starting with the judgment, the structure of it is that the learned judge starts at paragraph 368 by addressing the legal framework, which he does fairly between 368 and 371. The judge then summarises our case between 372 and 375. Just worth, by lords, just marking, when we get to after 375, there's two rogue, at least in my version, two rogue paragraph references under dealing in investments as principal. I've marked those 375A and 375B, because you then go on to 376 at the top of page 142. And the judge addresses at that what's new 375A, starting there, the various heads, starting with dealing investments and as principal. That runs from 375A to 378. And the judge there summarises our case that Bank Sarasin was dealing in investments as principal, and he accepts it at 378, and I'll be coming back to the detail. 379 to 381, he deals with arranging credit or deals in investments, and at 381 he accepts and finds that D2 did carry out relevant activities there. 382 to 384, he deals with advising on financial products and credit, and he says that at 384, subject to the question of whether Bank Sarasin was in or from the DIFC, he's satisfied about that. And that particularly follows from paragraph 383. I'll be coming back to that. And then he deals with arranging custody at 385 to 386. And he finds that he does say that it's accepted. That's obviously disputed whether it was accepted, but I will be coming to the arranging custody point shortly. And then he says that he finds that subject to the in or from the DIFC question. He then has a long section which starts at paragraph 387, which deals with the question of in or from the DIFC, and that runs all the way to paragraph 395. And what the judge there does is at paragraph 387, he refers to our written closing submissions. Do you see at the bottom of 387, claimants point to many instances which they say are evidence of relationship operating out of the DIFC. These are set out in Schedule 3 of the claimant's written closing submissions. and I'll be coming to those. And then at 387 to 390, he summarises the main points. 388 390 summarises the main points relied on. Now, I will be coming back to those. That's obviously a summary, and it's an important summary. Just to take a few examples, in 388 he deals with dealing in investments as principals, and he makes the point, for instance, at little 2, the instructions to purchase the investments were communicated to Bank Sarasin through Sarasin-Alpen employees based in and operating from the DIFC, in that the instructions forwarded by Sarasin-Alpen to Bank Sarasin were confirmed in a written document on the letterhead of Sarasin-Alpen. Confirmation forms were prepared and sent out from Sarasin-Alpen's office in the DIFC, and those forms were returned to Sarasin-Alpen's offices in the DIFC. Now that looks a rather dry summary, and the gravamen of it perhaps won't hit home until I take my lords to the documents that the judge is referring to. The judge then deals with 389 with quite a long section on arranging creditor deals in investments. And what one needs to keep in mind is the judge here is only trying to give a summary of the points that he's dealing with. One of the problems by letter from Mr. Malik's submissions is that he was rather reading the judgment as a statute. The judge is trying to give a flavour of the points that are being run. He's not summarising every point, because we had a lot of points which were additional to these. We had a lot of overlap, such that some of the points he summarises in one section were also points we were making in relation to another head, and so on. And one mustn't and shouldn't see the judge's summary as being exhaustive, because that's not the way any judgment ever works. The judge then goes on to list some other matters we rely on at paragraph 390. And then there's an important part of the... Then at 391, the judge summarises Bank Sarasin's case, which I'll be coming back to, where Bank Sarasin's essentially making submissions very similar to those made by Mr. Malik in this hearing. That's 391 and 392. One sees in particular reference to Bayshore. And then the judge says at paragraph 393, in my view it is beyond argument that other employees of Sarasin-Alpen, in particular Mr. Nair, made no distinction in their dealing with the claimants and Mr. Taha between the business of Sarasin-Alpen and the business of Bank Sarasin. The evidence that they saw themselves as dealing with the claimants in the conduct of business of Bank Sarasin is overwhelming. That Stephen Wernley, who was employed by Bank Sarasin as Department Head of Legal and Compliance Client Switzerland, accepted in the cross-examination that, on any view, Bank Sarasin was dealing with the clients from Dubai through individuals in the Sarasin office, and that there were many, many documents showing Mr. Nair or other Sarasin individuals emailing people within Bank Sarasin, plainly regarding themselves as part of the Bank Sarasin team. He accepted that the reality was that Mr. Nair was leading this proposed deal on behalf of the sellers of the product, Bank Sarasin, and indeed the people who were going to provide an element of credit, also Bank Sarasin. More pertinently, perhaps, that is how the position was seen at the time from within Bank Sarasin. Mr. Ewenberger accepted that Bank Sarasin dealt with its clients through a client relationship manager, and that that individual could be either an employee of Bank Sarasin or an employee of Sarasin-Alpen. He accepted that there was no difference in practice between a case where the relationship manager was an employee of Sarasin-Alpen and a case where the relationship manager was an employee of Bank Sarasin. In the present case, Bank Sarasin saw Mr. Nair as the client relationship manager. That's a very important finding, my Lord. The clearest example of that, perhaps, is in the letter from Credit Department signed by the Vice President and Managing Director of Bank Sarasin, by which the margin call was made. The evidence of Mr. Wernley shows he at least recognised that for Bank Sarasin to treat Mr. Nair as its own client relationship manager for the purpose of its dealings with the clients was inconsistent with its case, and that it was not carrying on financial services activities from the DIFC. And I'll be coming to a bit of that, but the point was that I showed Mr. Wernley some documents about how the relationship actually worked. Mr. Wernley's evidence as one can see from his witness statement, as one can see from the extracts my learned friend Mr. Malik took you to, tried to present a rosy picture of this distinct, separate relationship, along the lines of the relationship Mr. Malik was trying to suggest. What he's saying is, well, this is all normal, happens in every case. You have an arranger in the IFC, they're a distinct company, and then you have providers of products all over the world. That is just not what happened in this case. And when I cross-examined Mr. Wormley, he accepted that what had happened, on looking at the documents I showed him, was wrong and was not how it was supposed to be. And that is important evidence. 395, the judge says, I hold that whatever may have been the intentions of those responsible for setting up the joint venture through Sarasin-Alpen, the evidence before the court leads to the conclusion that, in practice, Bank Sarasin dealt with the claimants through Mr. Nair as its own client relationship manager. It was immaterial that Mr. Nair was employed by Sarasin-Alpen. His role vis-à-vis Bank Sarasin was indistinguishable from what it would have been if he had been employed by Bank Sarasin. That conclusion, as it seems to me, makes it impossible for Bank Sarasin to maintain that in its dealings with the claimants it was not carrying on activities which constituted a financial service in or from the DIFC, and impossible to maintain that it was not doing so in breach of the financial services prohibition. The judge then goes on at paragraph 396 to 399, and indeed 403, to reject the legal advice defence, which I will come back to, and to find an entitlement to compensation. And the last relevant paragraph on this part of the main part of the findings against the claimants, so against D2, is at paragraph 432. And indeed 433. Having cited arguments largely put by both defendants, the judge said, I do not take that view. I am satisfied the presence is a clear case of mis-selling unsuitable investments to an unsophisticated investor and to his equally unsophisticated wife and mother. That was carried out by employees of Sarasin-Alpen, motivated in at least the case of Mr. Alia by a personal interest fees to be generated by the excise and without regard to the protection of regulatory law. Bank Sarasin adopted a business model which led it to breach the financial services prohibition. It appears to have been content to allow the mis-selling to take place, in that it failed to exercise any adequate supervision over those whom it held out as its own client relationship managers, and then appropriate to pay compensation. So well, that's what we're actually dealing with. And we're not dealing with a hypothetical situation, as my learned friend Mr. Malik tried to create, of a rosy situation with a distinct entity operating in the DIFC, doing a bit of arranging and allowing all the dealing to take place elsewhere, and allowing the people elsewhere to exercise their own client relationship manager function separate from this entity. And I'm now going to go to but my first submission, obviously, is that the judge's approach was a thorough and appropriate approach. It turned crucially on a number of points of fact about how D2 in fact conducted its business, and the judge, as I'm going to submit, had a wealth of material which supported the conclusions he reached. Now, I'm going to go to some of the details in the schedules to my closing. Before I do so, can I just cover 2 points? The first is that I will be inviting the court to contrast the activities you're about to see in the material with the limited scope of what Sarasin-Alpen was supposed to be doing under its contractual documentation with Bank Sarasin. There was a very limited delegation agreement, and we've dealt with this in our skeleton of paragraphs 42 and 44. And the delegation agreement essentially allocated very limited functions to Sarasin-Alpen. And the contemplation of a delegation agreement is that the balance of the banking relationship would be conducted by D2. Essentially, D1 is conducting, on the basis of the delegation agreement, introductory type services. It's at H1 tab 105. H1 tab 105.
Thank you.
And the limitation, the content of a delegation is really at paragraph 1.
Yeah.
Delegates hereby authorised to verify the client's identity and to establish the beneficial owner, and also to carry out additional background investigations on the client and the origin of the funds being deposited. This information is non-transferable. And then, just the other point while we're on the document, it's worth noting paragraph 7, that BSC, that's Bank Saracen, is obliged to monitor whether the delegate undertakes the task entrusted to him with due diligence. To allow BSC to conduct these checks, the delegate agrees to provide its auditors access to all necessary documents and information, including those pertaining to its internal operations. That last point is just relevant when we come later to discuss whether there should be some forgiveness of D2. Now, the limitation on the delegation agreement is relevant because what my learned friend is trying to construct is an edifice where D2 is formally conducting an arranging function. The reality, as found by the judge, is that personnel, sorry, I didn't mean D2, I meant D1 is carrying out an arranging function. The reality, as found by the judge, is that personnel of D1 are carrying out D2's banking function. And the fact that what they're doing is so far outside the delegation agreement supports that point. And the second point is that we need to keep in mind there's quite an extensive banking relationship in this case between D2 and the claimants. There are sales and purchases of investments. There's structuring of investments. These are bespoke products being tailored to the claimant's requirements. There is lending to purchase the arrangements. There are security arrangements and there are custody arrangements. So it's a serious, heavy-duty banking relationship. And throughout the history of this relationship, on not one occasion do the claimants speak to anyone at Bank Saracen, and there is hardly any documentary communication between the claimants and Bank Saracen. And that is because Bank Saracen was conducting the banking relationship through these Sarasin-Alpen individuals. Now, my learned friend Junior has produced revised schedules, which I'm sure will be handed up in the course of the day. The important point, the schedules my Lord asked for in terms of the communications between the claimants and defendants. The important schedule to note is going to be the communications between Bank Saracen and the claimants. And what my Lord will see, if you actually look at the documents that are referred to, is leaving aside some margin call documents, which in fact support my case, which I'll be coming to. There is very little of substance showing the conduct of a banking relationship with a client relationship. In fact, nothing of substance showing the conduct of a banking relationship with a client relationship manager as between D2 and the claimants. I should just also put down one marker. There's quite a lot of the references on that schedule are to account statements and so on being sent out. It is just worth noting that there was a little bit of debate at trial about which statements have been received and so on, but in any event, that doesn't matter. What does matter is that those accounts, or might matter, is those account statements were just sent out in practice to D1 and then distributed. It's a small point, I just wanted to note it. Now, but the next point is that one of the indicia of the way in which the relationship was being conducted was that these Sarasin-Alpen individuals, Mr. Alia and Mr. Nair, all regarded themselves and were regarded by Bank Saracen as just part of the team. In relation to the first defendant's appeal, I know you'll be going through Mr. Walia's cross-examination. One of the themes you will see in that cross-examination is that I explored extensively with him the many, many internal documents between Mr. Nair, Alia and Bank Saracen individuals where they are all plainly just regarding themselves as part of a team. There's no corporate entity distinction whatsoever. And the customer-facing part of the team was Mr. Nair and Mr. Walia, who banked Saracen, providing its banking services through them. Now, my Lord, on this point, I'm about to go to Appendix 1 of my skeleton. Before I do so, it is worth reminding ourselves just of the pleadings in Bundle B10. In fact, I can just give you the references. You can turn them up later at the same time. Our pleaded case was that Mr. Nair was D2's client advisor to us. That was at Points of Claim, paragraph 42, Bundle B10. That was denied by the second defendant, and that is amended defence, paragraph 60, tab B19. That denial obviously was rejected by the judge in due course, and it was untenable on the face of the documents. Now, before I go to the detail of Appendix 1, I'll just spend a little more time on the client relationship manager point. An obvious example, which the judge referred to, of D2 treating Nair and Walia as their client relationship managers were in the margin call documents. You can see those at Bundle H3, tab 208. This is a Bank Saracen document. You can see that from the header and the footer on the page. It's addressed to Mrs. Hamad. This is the 29th September margin call. It calls margin, and it's from, one can see at the bottom of the page, Bank Saracen & Co., signed by senior executives at Bank Saracen. And in the penultimate paragraph, what it says is, if you wish to transfer additional securities or have any questions, please contact your CRM, Rohit Walia, telephone 0971. Now, this is classically a Bank Saracen client relationship manager function. It is a margin call being called by them. If you have questions about the margin call, you need to contact your client relationship manager, and the person identified is Rohit Walia. Now, in the cross-examination of Mr. Leuenberger, he accepted that the client relationship manager for Bank Saracen may or may not be a Sarasin-Alpen individual, or as the judge recorded in his judgment. Mr. Wernley sought to give a different picture. His evidence was that Bank Saracen actually did have a client relationship manager for the claimants. That came as something of a surprise on our side of the court. And there was a man called Mr. Morph, who apparently was sitting in Bank Saracen as notionally a client relationship manager, who had never had any communication or any contact with the claimants. And the person who was the client relationship manager for all purposes had been Mr. Walia and Mr. Nair. And one also sees at the top of the page, still on this document, Basel, 29th of September 2008, your contact person, Rohit Walia. You get the same point in tab 209. This is the margin call addressed to Miss Rifai. Top of the page, your contact person, Sharad Nair. And lower down, any questions, please contact your CRM, Sharad Nair. And the same point you get at 209A. You'll see there's an email sent to Mr. Khorafi. Over the page, Saracen document. This is the accelerated margin call. your contact person, Sharad Nair, and if you have any queries, please do not hesitate to contact Mr. Sharad Nair. And you get the same point in 209B, which is the other accelerated margin call.
The Shankar was who was she? Or he?
She was a D1 person.
Do we know what her role was or status?
Only, it's fairly clear she's junior to Nair and Wadi, I think, yeah? But we don't otherwise know. But just on these last two documents, probably also worth looking at the top paragraph. Again, keeping in mind this is a document from Bank Saracen, with reference to various top-up requests from our side during the last few weeks and to your last discussion with Mr. Sharad Nair, in which he draws attention to the actual worldwide market situation as well as our letter of 29th September. And so
sorry, where are you reading?
I'm reading the top of each of the last two letters, so either 209A or 209B on the letter from Bank Saracen, the top paragraph. It says, with reference to various top-up requests from our side, so that's Bank Saracen's side, during the last few weeks and to your last discussion with Sharad Nair, in which he drew your attention to the actual worldwide market situation, as well as our letter dated 29th September 2008. So no doubt at all that Sharad Nair is just part of their banking function for this purpose. And I've made the point that the signatories of these margin call letters were senior personnel at D2. Mr. Attinger, who's one of the signatories, was the person who gave the initial credit approval in this case. Could one also go to bundle H2? You can put bundle H3 away if you like. H2, tab 173C.
Give me the tab again.
Yes, 173C. Thank you. This is a document, we don't need to worry about the detail of it. It's an October 2007 document, and what it is one of the documents, and one of quite a few documents in a chain of Bank Saracen trying to unwind itself and from the IPO problem with ABK. And we don't need to worry about the detail. The point I'm taking you to it for is, firstly, this is another Bank Saracen letter, so it's Saracen logo at the top, Bank Saracen logo at the bottom. Addressed to ABK and your contact person, Sharad Nair. So again, a classic D2 function. It's trying to extricate itself from the IPO. So it's about, this is at using Mr. Nair as the contact person. Yes, but my junior reminds me I'm probably going a little bit fast on what's happening here. What they're doing is essentially restating the IPO and taking out the no lien requirement. So it's right they're trying to extricate themselves. The way they did it was quite craftily. They just purported to restate the IPO, removing the no lien requirement. But ABK weren't having any of it, and that's what led to the negotiation, which eventually led to the 20 million. Now there was, so obviously that makes it an important document from D2 side for which they're using Mr. Nair. Now there was cross-examination on this area. Mr. Neuenberger had evidence at paragraph 9 of his witness statement, which is at bundle E2, tab 72, page 3894.
page?
Yes, it's page 3893 and 4 in tab 72, paragraph 9. The origination and product development team of the financial engineering department at BSc currently together have 5 members. Their main function is to create structured products to service requirements of clients, including those of BSc and Bank Sarasin-Alpen. These teams do not have direct contact with the clients who purchase structured products paid by them. And very much in the background of the process, supporting as required the various client managers at BSc and its entities, which in turn liaise with the clients. At BSc, so there was intent, as Mr. Leuenberg later accepted, one could and perhaps normally would have a BSc client manager for this, but one could also, on the facts of this case, have another client relationship manager. This was then dealt with Mr. Walia, and if my lords could pick it up at D2, tab 57. Page 95, internal. Yeah, it starts at line 17. Bank Saracen, the Swiss bank, see Mr. Nair as from their perspective the client relationship manager. That's correct. This is very much Mr. Nair doing something on behalf of Bank Saracen as the client relationship manager from their perspective. He's conveying whatever Bank Saracen is wanting to get to the client. Yes, in that fashion, correct. He's seen by Bank Saracen as a customer relationship manager. A, answer correct. Then one goes on, page 98 of this transcript.
This is Walia, is it?
This is Walia. At the top of the page, you were seen by Bank Saracen as a relationship manager as far as they were concerned for Mrs. Hamad. Correct. And then on in the transcript, page 100 to 101, line 22. What about from Bank Saracen's perspective? Because they also have a relationship with these clients. As they see it, you're the client relationship manager from Bank Saracen's perspective. Answer correct, correct.
So which page was that, the last one?
The last one was 100 at the bottom to 101 at the top.
Thank you.
And then, still in this bundle, at tab 57, page 128 to 129, this is now Mr. Leuenberger's evidence. Starting at line 22 at 128, you never met clients, but you were designing products to meet clients' requirements. Yes? Yeah, that's correct. And you're essentially tailoring products for their needs, yes? Yeah, according to the requirements that are given to us by relationship managers. Exactly, you rely on the relationship managers to find out the client's requirements and communicate them to your team, and your team then structures the products accordingly. Yes, that's correct. What is happening is that Bank Saracen as a whole, if you like, if you look at the whole of Bank Saracen, is designing a product and selling it to the client on the basis that it meets the client's requirements. Yes, yes. But the interface between Bank Saracen and the client is the relationship manager. Yes, that's also correct. Yes. In many cases, that will be a relationship manager whose contract for employment happens with Bank Saracen. Yes, yes, correct. But in some cases, the relationship manager might have a contract for employment with another Saracen entity, such as Sarasin-Alpen. Answer correct. In that case, you were relying on Sarasin-Alpen. Now, the next passage is 132. Line 1, page 132 of this transcript, line 1. Question, let's just clarify it again. Is that relationship manager is the point of contact for the purpose of Bank Saracen, point of contact with the client? Yes. Bank Saracen delegates the process of ascertaining and communicating requirements to that relationship manager? Yes. Yes, but that relationship manager may have to be employed in terms of contract employed by Bank Saracen, or it may be relationship manager who's employed by Sarasin-Alpen? Yes. And then at 136 to 7, line 4 of 136, you're dealing with a hypothetical situation where there might be some third-party institution that comes in to buy product, but in this case we're looking at what you actually deal with on a day-to-day basis, yes? In fact, there is a relationship manager who's communicating with the clients and who's establishing the client's requirements and communicating them to you, so you can structure the products. That's right, isn't it? That's correct. That is a relationship manager who, in the most typical case, would be a Bank Sarasin employee who has a relationship with Bank Sarasin clients, yes. In the normal case, there are also cases where you have other Sarasin partners, if you like Sarasin-Alpen, where there's also a relationship manager. But that's the same relationship manager that you're relying on to communicate with clients to you, yes. Relationship manager is not just, as far as you're aware, your department that relies on having a relationship manager, because if there's a wider banking relationship, that doesn't just involve buying structured products, but also involves credit and the like. There will also be the credit department also relying on a relationship manager. That's right, isn't it? That's correct. If you go, for instance, go to bundle D11, tab 548, that is a margin call document. You don't need to worry at the moment about the detail of the document. It's a margin call document from Bank Sarasin. You see at the bottom it says, if you wish to transfer additional securities or have any questions, please contact your CRM. That would be client relationship manager, yes? Yeah, that's how I understand the abbreviation. Exactly, standard abbreviation. What we see here is Bank Sarasin's credit department, who they themselves, they also see Mr. Nair as the client relationship manager for the credit department. Answer, yes. Again, it's the same sort of thing, isn't it? It may be that the credit department it will have relationship managers who deal with their clients who are employed by Bank Sarasin. They'll also rely on relationship managers who happen to be employed by Sarasin-Alpen for clients in Dubai or Middle East. Answer, well, it looks that way, but I can't tell from my colleagues from the credit department. Page 140, line 13. As far as you see this all working, you've never detected a difference between a situation between how it works in practice where the relationship manager is a Sarasin employee, no difference from when it's a Bank Sarasin employee. Is that all? It's all the same. Answer, yes. Question, you're not a lawyer. I'm not asking you about law, but if there were any duties that Bank Sarasin had to advise the client about the transactions and risks, etc., of the transaction, I know that's an if, and I'm not asking you to opine on that, but if there are any duties to advise and so on, that's something that the relationship manager would generally be undertaking on behalf of Bank Sarasin, wouldn't it? Answer, that's what I would expect the relationship manager to do. And it's just important to pause on that point, my lords, because the judge has found this was an advisory relationship that Bank Sarasin had. So there were duties to advise, and such advising as there was undertaken only by the client relationship managers in the form of Mr. Nair and Mr. Alia. Last bit of transcript now is page 144, line 5. Question, would you expect the clients to then communicate the order to the relationship manager? Answer, yes. In this case, we have a relationship manager sitting in Dubai receiving the order, which is then communicated to your department or to your department for execution. Answer, yes. Now, well, against that background, can I go to the Schedule 1 to our closing submission, to our appeal skeleton, which is in bundle A. A2AC. It's called Appendix 1. It's at page 218-333.
No, 333, yes, I'm sorry, it's in very small print. Well,
yes. So it should read at the top, claimant's skeleton in answer to the defendant's appeals, Appendix 1.
Thank you, I have it now.
And this and the other schedule I'm going to come to is a reproduction of a schedule that's before the judge of our closing submissions. And, I mean, given the time, what I can't do is go through every example and take my lords to every document. What I will do is go through some of the main ones and perhaps look at a few of the documents. So, just starting at the top, we do say it's a consistent feature that all dealing with one Sarasin entity, rather than entities with distinct legal personalities. We then make the client relationship manager point, saying D2 rely on them to carry out that role, hold them out for being in that position, inter alia to obtain all written client's instructions for orders, negotiate the terms on which ABK could call the collateral, give advice where D2 had to advise, deal with margin calls, send out disclosure documents and terms and conditions. D2 was carrying on regulated activities in or from the DIFC. This is considered in Schedule 3. Just to be clear, these two schedules do related but slightly different things. What Schedule 1 is doing is dealing with the more general point, that they're all part of a team.
This is the we or us one.
Essentially, they're all part of a team. There's no distinction. A lot of this material is directly relevant to carrying on specified types of business, but the schedule isn't intended just to do that. It's to show how the relationship worked. What the other schedule does, which I will come to, is deal with specific types of business. So starting with paragraph 2, this is a document that's worth turning up. It's at H1 108A. Now this is right at the beginning of the story. Ms. Naz writes to Mr. Taha saying, "Thank you for your interest in Bank Saracen," not Sarasin-Alpen, Bank Saracen. "We are hereby very pleased to provide you the account opening forms, including Portrait 2006 with euro money on World's Safest Bank," that World's Safest Bank being Bank Saracen, and the account opening forms and so on. "We are looking forward in providing you with all required banking and investment services." Now, obviously, first, Sarasin-Alpen couldn't possibly provide all required banking and investment services, and this is a typical example of the confusion, and Mr. Alia accepted, as we note here, that the recipient of the letter would think they were just dealing with Bank Saracen, and that's really just the starting point. Staying in this bundle, moving on to tab 110, this is a document we've obviously spent some time on already, but looking at the first fact sheet, this is an important document for reasons we've already been to. Although it has a Sarasin-Alpen letterhead at the top.
We're looking at your paragraph, what, 2.2?
My lord, yes, and I'm also looking at
fact sheet of the 24th of April.
Exactly.
This is something dated the 29th.
I think that's a typo, Lord. I think that should be 29.
So that should be the 29th.
Yes, I'm grateful.
Okay.
But the document says global quoted, and I've referred to this paragraph before, global quoted real estate is the best performing asset class over the last years, especially REITs are highly attractive as of their liquidity and low correlation to other factory assets. Therefore, we offer a product with the underlying of 3 indices. Now, the offer of a product can only be done by the person selling the product, who is Bank Saracen. This was quite an important part of the communications between the defendants and the claimants with regard to their requirements and whether they could be met. And this is the product, or is supposed to be the product, of the first part of financial engineering and structuring, which the second defendant has carried on. And this is the second defendant's means of advertising its product to the claimants, which it's doing through Sarasin-Alpen at this stage. Then the next one, 2.3, I'm not going to go to the document, but it's an example of the sort of part of a team point. Clients, bankers this is internal. Clients, bankers are willing to release these funds to Saracen on condition we provide them a pledge. They're happy with Saracen pledge. Our FE team continues to liaise with Rabo as a product. I will keep you updated. So that's Mr. Nair, plainly just seeing himself as part of the Bank Saracen team. Email, another internal, the next one's external. It's 9th of May from Nair, so MN is Mohamed, so that's someone on behalf of the claimant side, saying our product management is working on the product actively today. our product management is a reference to D2 in Switzerland. Next one, 2.5. This is to Steve Chirin. He's the ABK man, and Mr. Taha, saying the text of the guarantee is done by our external lawyers. One point I should have mentioned, and this is dealt with at the end of the document, is that where everyone sees a double asterisk, that was intended to denote a point we say is also relevant to the specific dealing in investments allegations, or more directly relevant. Next one, we don't need to worry about next one, that's a more minor one. 2.7, file note by Mr. Nair. Mrs. Hamad has an account with us, and us is D2 because there's no account with D1. 2.8, we could go ahead with structuring this investment in two methodologies. 2.9, Nair to Nuremberg internal again. To the best of my knowledge, we have priced one version. And skip 2.10. 2.11, I would like to carry the same that we read to this document to Switzerland for discussion with our credit team. That was where Mr. Mohairi gave rather unsatisfactory evidence. Next one, 2.12, is perhaps worth going to. This is the document that one sees. I don't have the reference. For some reason we don't have that reference, so I'll just read it. What he says is, once this document is signed and executed tomorrow, I will create additional credit facility agreement for 35 million. So Mr. Nair is telling Mr. Taha that he's going to create the additional credit facility agreement. The next one, I'll come back to my just with the reference for that. Probably don't need to go to that. I will.
If you really want us to cross-refer these, it's not easy to do this as we rattle through, but it's not a complaint. It's just...
No, but I'm not going to invite my lawyers.
Okay.
I just think I'm going to run out of time if I do.
Yes, that I fully understand.
But I mean, what I will do, there may be one or two that are worth going to. Next one is 2.14. From Mr. Nair to Mr. Taha. Our current situation is as follows, and it sets out the collateral shortfall. And that's, again, quite an important area, because this line of correspondence shows Mr. Nair being used by the second defendant to conduct the banking relationship, in particular collateral shortfalls and the like. Next one, 28th of May, from Mr. Nair to Mr. Nur, post sending US dollars 80 million. We will have 8 million left for drawdown. Again, that's a D2 function that Mr. Nair is exercising. Next one, this is June 2008, cross pledge with regard to your discussions with Sharaf Nair to enable us to complete the cross pledge between the three accounts discussed. Request if you could please arrange for the attached cross pledges to be signed. Again, that is a D2 function, and Ms. Shankar is simply acting as D2's manager for exercising that function. Well, I can just give you the reference. We won't need to go through it, so, but just so you have the reference for item 212, it was H2, tab 160, page 6529. Sorry, I'm going to start again. H2 160B, page 6259. Next one, 217. Payal Dalal is a D1 person to Mr. Taha. We refer to our commitment to transfer 1.5 billion to Ms. Hamad's account. Our commitment, of course, is not D1's commitment, it's D2's commitment. Next one, Ms. Shankar to Mr. Noor. I'd like to confirm that we do not have standing instructions. The commitment we have is 5 times payment of 1.5 million. So again, that's a D2 function discussing what the commitment of D2 is in relation to the coupons to ABK. 219, collateral shortfall document. 220, Ms. Shankar to Mr. Nur, post the payment we had done to ABK, we had to book the irrevocable undertaking to pay on the account of Alia Rifai as per request received. Again, D2 function. 221, we have the following fixed advances that need to be serviced for coupons due to enable us to manage subject accounts LTV. We will be servicing the fixed advance interest. Should you need additional confirmation and clarification, please not hesitate to contact us. So we can see a pattern, and there are 2 points. Obviously, the we is significant because it shows a complete blurring of the lines, but that's not the only point. What it's also showing is they are in fact carrying out D2 functions, because perhaps not every single document, but certainly all the asterisk ones that are in there are all part of D2's relationship that ordinarily would be carried out by a D2 person, but in this instance they're using a D1 staff member as the judge found. Next one, we then actually go on to the margin calls and so on, so I've been to those. So we can then go to paragraph 3 of the schedule over the page. A lot of those documents, in fact nearly all of them, were from the D1 side, but that wasn't always the case. So there's D2 also is part of this arrangement and thinks the same thing, and we referred to some of the documents here. We say press release in which D2 says it has a strategic presence in the region for its DIFC domiciled subsidiary. Dubai is a good starting point for us in the region. We obviously have plans to offer our services to other countries in the region. And then there's the confirmation of irrevocable payment order, referring to Mr. Nair as your contact person. There's a press release from Banker magazine in which the head of the division says our determination to attract such talented individuals as were represented by the Dubai team fully represents Bank Sarasin's commitment to Dubai and the Middle East. Then there are documents that I think I've been to already. Don't worry about paragraphs 4 and 5 for this on this point. Paragraph 6, again, less significant, except 6.2 is worth noting. Mr. Alia, we are one team for sure, but we operate as different entities. Question, when you say you operate as different entities, you are legally structured as different entities, but in practical terms you operate within a team from day to day, individuals speaking on the phone, emailing each other. Alia, correct. You're all part of a team. Correct. And then paragraph 7, where we just explain about the asterisks, and just make the point that D2 delegates D1 performance banking functions, including client relationship management role, where D2 operates in the same way it did for its other clients, but just happened to use D1 personnel as the client relationship manager. As a result, all communications within the contacts relationship, for instance with regard to collateral margin, were undertaken on D2's behalf by D1 personnel. And that takes us to Schedule 3, where we deal more specifically with the activities. And as we say there and said to the judge, and as we maintain today, paragraph 1, the idea that D1 is an independent entity acting at arm's length was shown to be unrealistic, and D2 did delegate conduct and management of D2's relationship with the claimant to the first defendant. And then I've summarised paragraph 3, the key points. I simply invite my lords to read paragraph 3. then paragraph 4 essentially makes the same point. Even making the point, even the 20 billion payment in the UK was dealt with in this way, no objection raised by D2. Now, we then deal with dealing with investments, and should, just before I do, if I want to see at the end of paragraph 4, you made the point, even the 20 million payment to ABK was dealt with in this way. There's a reference there to footnote 11, which is the document at H3201A, which is worth taking up. This is a payment order with reference to the amendment transfer amount of 20 million to the account favouring Amrah IAA referring to ABK. On the other side, the client requested transfer of sending out people to the amount of 30 million to said account. To meet the above requirements, please provide a fixed advance shortfall for a tenor of 1 month. Finally, your immediate response will be highly appreciated. This is the client instruction for the transfer. There's in fact no communication and no passing on of this instruction at all in written form to D2. And indeed, on the document, he directs the payment instruction simply to D1. No mention of D2 at all. Now, back onto the first topic, dealing investments, and just to be clear, this is the big point in the case against D2. We've obviously got 4 specified activities, and I will spend time on arranging and custody and so on, but the point that matters most is dealing in investments, because that really most obviously feeds the compensation awards that have been done, because all of these activities, all of the investments sold, constitute dealing in investments by D2 in breach of the regulation. Now, paragraph 5, we make the general point that the first event was at the heart of the investment sold. It wasn't simply marketing and putting the claimants in contact with D2, it instead acted as D2's office in the IFC. It was sufficient for the claimant to speak to someone in the DIFC or send a document to the DIFC for D2 to take action. Thus, sending an account opening form or a signed credit agreement or pledge agreement to the DIFC led to D2 taking action, even if the document was not received in Switzerland until much later. And that's the point I'm going to come back to, Mr. Neuenberg point. Paragraph 6, I just invite you to read quickly because that's a less significant point. The 2 points one particularly gets out of paragraph 6 are over the page at the top. Firstly, the forms state they are processing with the IFC and identified Mr. Nair as a person processing the application, and the accounts were opened on the 26th of June, but the form was not received until later. Quite a striking point. And the bottom point, the investments were already put on before the second defendant received the application forms in Switzerland. Now, we then go to paragraph 7, which is at the meat of the case. Firstly, second defendant delegated to the first defendant the role of obtaining instructions to deal. Next, and there's a transcript reference there, it's probably worth having the transcript open. I'm not sure I'm going to go to all of them, but it's worth just having the transcript open. To D2, page 57, tab 57. That one's at 1492. Internal page 201, 235, line 23 to 236, line 5.
Sorry, 201.
Internal page 235.
Oh, 235, sorry, I missed that.
The relevant.
This is who?
This is Mr. Wernley's cross-examination. So his lordship, they were authorised to use your brand, were they? Sarasin-Alpen was authorised to use their brand, the tree brand. Yes. This document suggests, dear Sir, Madam, in the last paragraph, it authorises Bank Sarasin to debit a bank account for the purchased product. Is this a document that Bank Sarasin relied upon in debiting the account of Mrs. Hamad? Yes, we see it as the instruction to deal. And the instruction to deal is on the confirmation of investments form. And I think this was accepted by Mr. Malik. And that is the form that D2 relied on. And yes, one can see an example of confirmation of investment form at H1 tab 129. And what's going to be quite important is to understand the actual sequence of events of how a deal is put on. So one has a confirmation of investments form at H1 129.
Yeah.
And that document had to be signed by the claimants and returned to the first defendant. And the second defendant's case, as repeated by Mr. Malik, is that that is the contractual document which authorises them to deal. And those were sent out from the DIFC and returned to the DIFC by the client. And what Mr. Alia said in his evidence, and again I'm reading from paragraph 7, is that the confirmation investments were addressed to the first defendant in Dubai and were then passed on by the first defendant to the second defendant. Now, Mr. Nair, then, in sending out the confirmation document and sending it back, is authorised to do that as part of D2's investment activity for the dealing in investments. And one can see an example of the process at tab 120.
H1 120.
Tab 120.
Yeah.
Sorry, that's the wrong reference. Sorry, that's the wrong. Sorry, that's the wrong reference. Well, would you bear with me for 1 moment? Yes, sorry, I'm going to take. It's 121. Thank you. Yes. So Mr. Nair is sending out at tab 121, sending out the document saying, please attach the judgment wherever. So
Now this is cross-referring to something in paragraph 7, is it? You've slightly lost me.
yeah, no, but it's my fault, my lord. should be, yes, it is. It is cross-referring to footnote 24. Sorry, I'm losing you because I'm trying to sort of accelerate through it, but it's my fault.
I fully understand the need for some dispatch. It's just,
No, I understand.
I occasionally get left behind.
Tab 120, bundle H1. This is Mr. Nair sending a document out to Mr. Taha saying, attached, please find the term sheets and numerical example of the formula. Mr. Rafed and his mother will have signed the attached term sheets and investment confirmation form to execute the investments. So it's making clear that he's sending those out from DIFC and they have to be signed and then they're to be sent back to him. And one can see attached to that is the confirmation of investment form at the back and the end of the tab, which has a Sarasin-Alpen letterhead at the top. So it's a Sarasin-Alpen confirmation of investments form. And that was what Mr. Wernley accepted in cross-examination, was sent with the authority of the second defendant with the intention that he would rely on it. And Mr. Alia also confirmed the documents were to be received in the DIFC, and I've given the reference to that at footnote 28 in that schedule. Well, without going into any more footnotes, just reading briefly to the end of the paragraph, the term sheets attached to the confirmation investments include a page of illustration, which is a non-standard page, clearly entered by SN. In short, D2 was happy to use documentation created by D1 as a binding instruction for the client to execute the investment. Further, it was the receipt of the documentation in the DIFC which appears to have led to the deal being done, since D2's records showed that the written instruction was not received in Switzerland until after the deal was done. This was a consistent feature of the relationship between D2s and the Cs. So this is a very important point, my lord. The deeding instructions are sent out in draft on behalf of the second defendant and received back in the DIFC. In each case, Sarasin acts on the deeding instruction, the confirmation of investments, and Sarasin does so before it even receives that document in Switzerland. And we can see exactly an example of this process. If we start with H1, tab 128. This is the confirmation investment form in relation to the first set of REAP notes. So, as I've said, it's on Sarasin-Alpen letterhead. It is authorising at the bottom, we hereby authorise Bank Sarasin and Company Limited to debit our account for the purchases of the above mentioned product on or before the settlement date. And it's that one signed. One then needs to go in bundle H2 to tab 138D. This is in relation to the same trade. So we know that this is sent back to the DIFC. And in relation to the same trade...
Could you just give me the tab
yes,
again?
it's 138 in H2.
Thank you very much.
138 or 138C?
Oh, 138D. Sorry, 138D.
D.
138D, I apologise. This should be
138D. D for David.
Exactly, yeah. Should be an email from Matthias from Nuremberg. Going down in the email, about a third of the way down the page, we see that on 25th of June, Mr. Malpani, who's a Sarasin-Alpen person, is saying to his Swiss colleagues, please trade the following with Rabo. So, and then he's setting out the investments. And then the response is from Switzerland, same day, 6:59 p.m. Solution just received the confirmation from Rabo. Rabo, of course, is the issuer on this trade. Prices as shown are fine and done. Fixing the index levels will be made tonight and tomorrow morning. Congratulations once more and best regards. Now, this is not remotely arranging deals and investments on the part of Sarasin-Alpen. This is dealing in investments. They have received the confirmation from the claimants in the DIFC. They are, without even passing the confirmation to Bank Sarasin, Mr. Matthias is saying, please trade. And Mr. Leuenberger is acting on that and putting on the trade.
Now that's in your footnote.
That is the point that's made at the end of paragraph 7.
Oh, I see. Yeah.
And so the trade is done on the 25th, although what Mr. Leuenberger makes clear in his part, that the fixing the index levels won't be complete until the next day, the 26th. Now, it's worth noting that the accounts in this case weren't even opened until the 26th of June. So this trade is done before the accounts are even open. The judgment on that point is at paragraph 19. And to complete the sequence, one needs bundle J1, tab 274. This is Bank Sarasin's record of the trade. J1, tab 274, page 6863. Bank Sarasin say, this is dated 28th of June, according to instructions from 28th of June 2007, on 26th of June, we purchased on your behalf OTC other markets. Now, what that's recording is, as we've just seen from the email, they put the trade on the 26th of June, because that's the following day when they fix the indexes, but they don't get the instructions until 28th of June. So in other words, although D1 has said do the trade, Bank Sarasin don't receive anything which are the instructions until the 28th of June. And you see that pattern in every single trade in this case. And to give all the references, or the transcript, the references, one needs to look at J1 276, pages 7105, 7110, which in fact was a 6-day delay, 7111, 7112.
Now this was after the receipt from the claimants, the first claimant, of a documentary instruction.
Well, the evidence doesn't show that. It may well
have.
be.
One.
I've shown you the documentary instruction. We don't know when that was received. It may well have been, and perhaps the likelihood is, they have received the confirmation of investments in the DIFC. That doesn't matter to my case. Let's assume they have. Otherwise, they really are taking a flyer. Let's assume they have received it in the DIFC. They are still, it is their call. They are phoning or emailing and saying, put on the trade. And it's nothing to do with D2 receiving the confirmation of investments in Switzerland. So this is completely contrary to the position as put by my learned friend Mr. Malik. Mr. Malik's case was the deal is done on the confirmation of investments. What matters is acceptance, or where you receive acceptance of confirmation of the confirmation. And he said they received it in Switzerland. Wrong. They received it in the DIFC, and they acted and traded on the basis of receipt of the DIFC with the DIFC person putting on the trade. And that is dealing in investments in and from the DIFC. And in my submission, there couldn't be a clearer case of it.
Well, to steer clear of dealing in investments in DIFC, the clients have to send the confirmation of investment themselves direct to D2.
Well, that would certainly help my learned friend's case. It would have helped my learned friend's case.
Now it would say, well, this is consistent with D1 acting as a sort of channel of communication.
Well, that just doesn't work. He's not passing on the confirmation. They don't know. They have no confirmation from the claimants. All they have is D1 saying put on the trade.
It
is much more. I'm sorry.
Forgive me for interrupting you. I'm sorry. It wouldn't be implicit that the confirmation must have been received before D1 give the instruction by email to make the trade.
Well, I don't know. It may or may not be. My Lord, this is much more in line with the judge's analysis. But what this is really showing is D2 has a person it uses in the DIFC who receives the confirmation and executes it as it gives instructions to put on the trade. That is what we're seeing. And the analysis that this is the sort of arranging function that my learned friend Mr. Malik said is just terribly far from this case. It's wholly artificial. I mean, I can understand how my Lord puts it, but it's the most artificial way in my submission of analysing what's happening here. Yeah. And in my submission, this gives an unanswerable case on the question of dealing investments. And the learned judge well understood this point, and it's what he's summarising at paragraph 388.2 of his judgment. And as I said earlier on, when reading the somewhat dry wording at 3882, it is quite easy not to fully grasp the gravamen of the point.
There was no account between D1 and D2.
No.
So these would have been booked in the books of D2 to an account with the claimants.
My Lord, yes.
There was no intervening entries
No, that's right.
on an account with D2.
That's right. But well, can I move on to my schedule to paragraph 8? So these two relied so heavily to then identify that for some of the investments, products sold materially different to the product that the client had agreed to buy. That's it. Reference to the energy basket notes, or that confirmation of investment form would not be received, as was the case for C3. That's a good example, I think, coming back to my Lord Sir Richard Field's point. In one instance, it looks like there never was receipt even of the confirmation of investment reform. And so another indicator that the trade is just being put on by D1. And similarly, D2's reliance on D1 in C3's case, Field's done on the 12th of February before D2 received a power of attorney This shows the extent to which D2 delegated to D1 the role of securing funds and trusts to give independent thought to the matter. D1, this is a point which is, I think, not really, I'm not sure it's really taken now, but just this was a point which was taken more below. D1 currently acting as agent of seizure and passing D instructions to D2. First, D instruction was a different price. Second difference in price was taken as commission by D2, and then remitted to D1 under the arrangements D1 to do and vacuum is going to seize. D1 clearly acts as agent for D2. That's shorthand. That really should be read consistently. The rest of the points are advanced to the judge. It's not so much looking at D1 as acting as agent. It's D1's personnel. And this comes back to a point I'm going to be addressing in relation to Mr. Malik's more general point. He says, oh, we've never said that D1 was dealing in investments as agent. Quite right. And that's not what the judge finds either. D1 was not authorised to deal in investments as agent. D2 wasn't authorised to deal in investments as principal in the DIFC. What was in fact happening was D2 was dealing in investments as principal from the DIFC. D1 was facilitating that because its staff were being used as D2's personnel for that operation. It's not a question of D1 dealing in investments as agent. Then there's paragraph 10, where we say further once the deals were done, D1 took the role of confirming the trade overseas, account statement sent out, and so on. Further tasks dedicated to D1. D2 document didn't even have C's address on, simply Kuwait. Appears D1 also responsible for sending out the term sheets, although this is not something that was ever done by D2. Although D1 does not appear to have sent these out until long after the events, as Mr. Bloomberg said, the term sheets are meant to be sent out 1 or 2 days after execution. So, Lord, we submit there can be no answer to this part of the case and no possible grounds of appeal, which is fatal to the appeal by my learned friend as a whole, and that justifies the judge's conclusions irrespective of the other regulatory points on the less important areas, which I will still have to come to, I accept. And having seen, obviously, just a sample of some of the material and the points we make, I would say Mr. Malik's submission about the separation of the operations is just wholly at odds with the facts of this case, and the judge's approach at 393, 395 of the judgment was spot on. Now, Lord, can I deal more quickly, I hope, with advice, which is, I'm going to skip for the moment arranging and custody, because there are some legal points taken by my learned friend, which I think I need to deal with first in order to really give proper context to how we address those points. Advice, I will deal with quickly now. We deal with that at paragraphs 12 to 14. Don't worry for the moment about paragraph 12, but for time I would just invite my lords to read paragraphs 13 and 14 in respect of advice. Well, can I now turn to my learned friend's appeal against all of that, I apologise, quite lengthy background. The first ground of appeal, and the main ground of appeal, is the suggestion that Bank Saracen were not in breach of the financial services prohibition. And we make some threshold points. The first is that this is not a question of what other institutions might do, or even a question of what Saracen might have wanted to do or hoped that it might have been setting up. As we explain in our skeleton at paragraph 410.2, Mr. Wernley's evidence was that what happened in this case shouldn't have happened and was wrong, and we've given references to that at footnote 319 to paragraph 410.2 of our skeleton. And could I just turn up very quickly what Mr. Wernley said about that? Mr. Worney's evidence is a bundle D2. It's tab 57, starting at page 199.
Sorry, just repeat the date again.
Tab 57, internal page 199. 199, yeah. Starting at the top of the page. The point is that Bank Saracen are regarding Mr. Nair as being the client relationship manager. That's true on the credit side as well, as we can see from the margin call document. Answer. I mean, that's one letter. I can just say yes, this letter states. His Lordship, your answer to me is they got it wrong. Yes. You're head of legal, Mr. Worney. If it was on my desk, I would not allow him to send that way. As head of legal, I expect that when you look at documents like 3309 and 3313, you're slightly uncomfortable, right? Yes, of course. I would be too if I was head of legal of your bank. But what we have, and you have seen all the documents, is a massive documents from Sarasin-Alpen, which suggests they think they're actually part of Bank Saracen. That's not your problem, and it wouldn't matter what Sarasin-Alpen was saying, but there is a massive documents in which they refer to themselves as if they're part of Bank Saracen. What's much more important from my point of view is what Bank Saracen is saying. If you look at pages 3309 and 3313, you'll find that when Bank Saracen writes to the customer, there are very few documents in which it does. It tells them, the customer, that Mr. Nair is the contact person. That's underneath for date. This is the bank, your bank, telling the customer if they want to deal with you, they do it through Mr. Nair, and then you find they're telling the customer that he's your CRM. Your best answer, I don't mean this impersonately, is that your managing director and vice president have just got it wrong. I expect they did from your point of view, but these are the documents. Answer, that is precisely the case, my lord. I then say, on any view, when it was offering to sell tailored products to clients and structuring the products, that Bank Saracen was relying on Sarasin-Alpen individuals both to communicate the client's requirements to Bank Saracen and to communicate back to the client what Bank Saracen could offer. That's right, isn't it? Yes, that's right. It was also relying on Sarasin-Alpen individuals to do the actual business of dealing with the client in terms of receiving the client's instructions to trade. Yes, they have the authority to receive instructions and forward the instructions to us. That is then relayed to Switzerland by the Sarasin-Alpen side, yes. Can you say the other words? That is relayed. That is then passed on, yes, to Switzerland by the Sarasin-Alpen side. I would suggest to you on any view that Sarasin-Alpen was dealing with clients from Dubai from his individual Sarasin-Alpen office. Yes. Indeed, the clients would only be dealing with personnel in Dubai and DIFC. Yes. The next passage to go to is at 218 and 219. Top of the page, 218. If you go to bundle D2, tab 21, this is an email from Mr. Nair to various people in Bank Saracen, and they all on the credit side. Can you help me? Benjamin Zugan, Peter Attiger from the credit department. What about Gerhard Kruger? Gerhard Kruger is from the compliance department of Sarasin-Alpen. What Mr. Nair is saying is, he's saying, he refers to our FE team. Our FE team, presumably is Bank Saracen's financial engineering team. Answer, I don't know. Mr. Nair says, on the condition we provide the pledge, would you expect him to be referring to Sarasin-Alpen providing the pledge? I guess not, no. I'm not going to spend a lot of time with you on this, but this is one of very many documents in this case showing Mr. Nair or other Saracen individuals emailing people within Bank Saracen, plainly regard themselves as part of the Bank Saracen team, using expressions such as we and us. Does that surprise you, or is that what you would expect? Answer, once more, I don't really like it. Question, you may not like it, but it isn't the reality that Mr. Nair was leading this proposed deal on behalf of the sellers of the product, Bank Saracen, and indeed the people who were going to provide an element of credit also, Bank Saracen. Answer, yes. The next passage is 224, on the same page, so 224, starting at the bottom, passage starts at the bottom of 223. Could you go to bundle D5? This is a document from Bank Saracen itself. I don't know how closely familiar you are with the history and facts of the case, but the background to this is an attempted variation of the letter of commitment that Bank Saracen attempted to effect in writing, by writing in October 2007, a revised letter of commitment and sending it to ABK. Do you see who the contact person is for ABK on the Saracen document? Yes, I do. That's again, I can just restate. It's not good that Mr. Sharad Nair was mentioned on that letter. I was not involved when that letter has been drafted. Question, it may not be good from a legal and liability perspective. Answer, but I do. But what this is reflecting again is the reality, which is that Mr. Nair is the contact person. The person you speak to deal with Saracen business. That's right, isn't it? Answer, yes. Question, and then there's a reference, then there's something from the judge. Just before you leave 251, Mr. Wormley, this really all arises perhaps because in your witness statement, paragraph 25, after referring to the post box, you say the first defence relationship was conduct pre-contractual potential client identification. What's being shown to you in the document you've just been looking at is the bank, your bank, in a document signed by Mr. Bobby and Mr. Attinger, who's your vice president, your managing director, telling ABK that the contact person is Mr. Nair. I should have to try to understand how, if at all, I can reconcile what you're saying in paragraph 25 with these letters from your bank telling people to regard Mr. Nair as the contact person. Because your bank is, on the face of these letters, using him for a purpose which is much greater than that in paragraph 25. I understand you to say they shouldn't have been doing it, but that's what's happening. Answer, that's wrong. It's wrong, yes. And what he's saying wrong is not wrong, not his lordship's wrong. He's saying what's happening is wrong. And you can see that because the judge says, yes, you don't like it because it's very inconvenient, but it is happening. It doesn't sit very easily with your witness statement. That's the point. Similar, there's a wide acceptance on Mr. Werney's part that what was happening was wrong. And again, that makes it difficult for my learned friend to make the submissions he does, that this is some sort of floodgates case, and that what the judgment has done is set a cat amongst the pigeons with the way people conduct, or banks conduct business in Dubai. That was a submission from the bar, evidence from the bar. There's been no fallout that I'm aware of from this case. And this is a case that turns on the facts as found by the judge, and the unique facts of this case and how they in fact carried on business. The second threshold point is that, well no, I'll come to this later. The next threshold point is a point from my learned friend that because there's a breach of the rules could result in a fine, then your lordship should construe the financial, all the COB rules very narrowly. I think that's a submission. There should be no such presumption in my submission. One might equally say, or more persuasively say in my submission, that they should be interpreted broadly, or at least naturally, because these rules are about consumer regulation. Now, turning to the individual categories of regulatory breach, starting with dealing in investments as principal, it's common ground that Bank Sarasin did deal in investments as principal. The only issue is whether they did so in or from the DIFC. And there's a wealth of material which I've been to, which in my submission demonstrates that they did. My learned friend suggested that Gen 2.7.4 gives Bank Sarasin a get-out, and we should take that up. It's in bundle G3, tab 92. G3, tab 92, page 5639. What Gen 2.7.4 says is a person who is not an authorised firm or an authorised market institution does not deal investments as principal in relation to an investment by entering into a transaction with or through an authorised firm or a regulated financial institution. Now that does not give Bank Sarasin a get-out. First, Bank Sarasin was not dealing with or through an authorised firm. It was contracting directly with the claimants, and to the extent that Sarasin-Alpen had a role, they were not interposed in the contractual dealing relationship, which was a straightforward, Sarasin-Alpen claimant relationship. Secondly, Sarasin-Alpen wasn't authorised in any event to deal in investments as agent. And the one thing these rules do not do is create a regulatory black hole whereby someone, as here, is dealing in investments out of or from, or in or from the DIFC. Sarasin-Alpen aren't authorised to deal as agent. Bank Sarasin aren't authorised to deal as principal, but it's somehow all right. If there is dealing in investments in or from the DIFC, the person dealing, or one of the people dealing, need to be authorised to deal. So it doesn't help at all, my learned friend, to say that D1 was authorised either to advise or to arrange deals and investments. Because we're looking here, there is dealing in or from the DIFC, not just arranging, there's dealing here. And because there's dealing here, someone needs to be authorised to deal, either as principal or as agent, and no one is. And arranging just doesn't help my learned friend, even leaving aside the judge's findings that what's happening is Sarasin-Alpen isn't actually conducting any formal role on this as agent. As the judge found, it is just their personnel who are being used to do Bank Sarasin's dealing. And it's on that point that my learned friend said, well, the confirmation had to be received by Sarasin in Switzerland before anything happens, which was wrong, because the confirmation was received in DIFC for things to happen, and indeed acted on and traded on without them being received in Switzerland. The third point on this, actually I've jumped ahead of myself, it's the point I've just made. The judge wasn't finding a formal and general agency of any kind on the part of Sarasin-Alpen. His point, which is clear from paragraph 378 of a judgment, is that the individuals are being used by Bank Sarasin to deal. And again, as the judge quite rightly picks up, one reminder about why this is so is that the delegation agreement was very limited. This is the point I started with. That Sarasin-Alpen wasn't authorised under its own delegation agreement to be the person through whom Bank Sarasin was conducting business. It had a much more limited introductory role, and that reflects the reality that it was Sarasin-Alpen's staff acting for Bank Sarasin in the DIFC.
But from a narrative,
Yes.
in order to attribute Mr. Lair, Mr. Wiley's activities to D2,
Yes.
do they not have to be agents?
Well, I suppose those individuals are, in one sense, agents, but they're certainly not authorised to deal in investments as agents. And they are nor are they authorised, they're not entities that are authorised to arrange credit. The only person authorised is Sarasin-Alpen. But I suppose my Lord is right. It is probably inherent in the judge's findings that using these people in the way Bank Sarasin was must involve some kind of agency.
That old ancient old law where an employee of X is borrowed by employer Y.
Yes.
And the employee's acts are attributable to the borrowing employer.
Well, I think that must be right.
It used to have a lacking tag to it, which we didn't go into. I'm forgotten it anyway.
My Lord is more learned than me.
I know.
I may be repeating myself. I've got this down as a next point, which is that my learned friend appeared at one stage to be suggesting it helped him that there wasn't a formal, proper agency arrangement for this sort of activity with the first defendant. He seemed to be saying that the dealing was nevertheless through Sarasin-Alpen in some nebulous way that still gave him a get-out under 274. But that, of course, doesn't work, because the dealing, as I've said, the dealing wasn't through D1 in any official capacity, and D1's regulated, the regulated activities D1 could do wouldn't suffice for what its staff were in fact doing on this transaction. And there's, as I say, no regulatory black hole. Now, the next point from my learned friend, Mr. Malik, is he says there can't have been dealing in investments from a DIFC because the relevant time is when the confirmation of acceptance is received, but that fails on the facts, as we've just seen, because the confirmation was received and acted on when it was in DIFC and not Switzerland. That's, as I understand it, the objections on dealing in investments as principal. We then go to advising on financial products and credit, and I've given examples of that activity in Appendix 3, and my learned friend Mr. Malik says the judge wasn't properly distinguishing between advising on behalf of D2, if you like a D2 advisory role, and advising on behalf of D1, the D1 advisory role, because D1 was permitted to advise. Now, in my submission, the judge was aware of that distinction, and it's the point he's making in his judgment, that they are performing D2's banking functions, including D2's advisory functions. So, for instance, as I've said, the judge found for us at paragraph 413 of the judgment, he finds it was an advisory contract. He satisfied that Mr. Nair did hold himself active in performing services for Bank Saracen, and that Bank Saracen acquiesced and endorsed his conduct in that respect. On the evidence court, I hold a financial advisory contract with Bank Saracen. Each of the claimants did arise under Swiss law. So he's finding that's a factual question. He's finding that there is a advisory contract, and the person doing any advice, that is D2's advisory side, is Mr. Nair. It's the D1 personnel. So the judge is making a distinction, contrary to my learned friend's submission. And the judge had no difficulty in drawing a line between D1 type advice and D2 type advice. The judge referred at paragraph 383 to certain types of advice, which is not intended, as I said earlier, to be a comprehensive description or an exhaustive description of all the points the judge had in mind. The judge did refer to some points at paragraph 383, and he was right about that. Marketing presentations were produced. They included not only the term sheets, and I accept my learned friend has some points on the term sheets about them being quite restrictive, both in their content and in warnings and so on, but also there's the fact sheets. That was produced by a combination of Mr. Nair working with financial engineering to explain and structure the product. And that fact sheet with its rosy picture that it says at the beginning is clearly advice on the merits and a puff piece, and indeed a recommendation. And that's part of the D2 advisory function. But the judge also referred to structuring investments, and that's really the same point. The evidence brought out that the way this works is Mr. Nair or Mr. Walia with financial engineering in Switzerland are tailoring a product to meet the client's needs and then recommending it to the client. That's what happens. That's what the judge found in his judgment. And that involves an advisory role that is part of the D2 advisory role, because it's saying, look, we've tailored this product, this is what we can do, and then what's said is, why don't you buy it? The next topic is arranging credits or deals and investments, where my learned friend has some more technical points. The first one relates to Gen 2.9.2, which is again at G3 tab 93, page 5640. So on arranging credits or deals and investments, there is an exclusion for any arrangements for a transaction into which the person making the arrangements enters or is to enter, whether as principal or agent for some other person. Now, my learned friend is right to say this helps him to some extent, but it doesn't, in fact, get him out. And the reason for that is that Bank Saracen was, in fact, purchasing the product in the market. So one has to remember the actual chain of relationships in this case. The client purchases a product from Bank Saracen. That product involves Bank Saracen doing some financial engineering and then going out to buy the product in the market. There is then a direct economic and contractual relationship between the issuer in the market and the claimants. So, for instance, your actual entitlement to interest on the notes and so on isn't an entitlement to banks that as against Bank Sarasin, it's entitlement as against the issuer.
Well, it purchased from Rabobank, didn't it?
That's the first set, and then the other sets were from a different Sarasin subsidiary, but not Bank Sarasin.
Well, are those purchases in the market if you go within the group?
Well, my lord, there's purchases from a third party.
Third party.
Yes,
That's enough.
yes, but also. So, what we have here is there is still a third-party relationship which Bank Sarasin is arranging. And so they were, as well as dealing as principal, they were also arranging deals in investments. And they're obviously also dealing as principal because they take a turn. So what you buy from Bank Sarasin is the product from the market plus something on top because you're buying it from Bank Sarasin. So they are certainly dealing as principal, but they're also arranging the relationship as between the claimants, the relationship that then ensues as between the claimants and the issuer of the product. Now, as regards credit...
So can I just come back to 292?
Yes.
They were excluded from Rule 291, which is making arrangements for another person to subscribe. Any arrangement for a transaction into which the person making the arrangements, that is, for this purpose, D2, is it?
Yeah, putatively D2.
D2, in which D2 enters, or is to enter, whether as a principal or as an agent for some other person.
Yes, so
it excludes any arrangement. He's obviously going to be entering into it either as a principal or as an agent for any other person.
well, my lord, I think this is the point Mr. Mallet sought to answer. I think I agree with him. What this is trying to get at is if you only have an arranging function, then you are liable. But if your arranging function leads to you then being part of a trade, either as principal or as agent, you're in the exclusion.
Okay.
I think that's common ground on that. So that's why he says we can forget agent, I think, unless he says otherwise. I think we forget agent. His point is that because Sarasin sold these investments as principal, it brings it into the exclusion. And I say that's not right because there's also the other limb of it, which is it has a pure arranging function in respect of the relationship as between the claimants and the issuer. Okay. The next one is, and in respect of that arranging function, I should just make clear, my learned friend has, well, I think he does say, well, why was that anything to do with DIFC? Well, the answer to that is as Mr. Neuenberger explained in his evidence, Bank Sarasin needs to know the client's requirements and to tailor the product and to liaise with the client in relation to its requirements in order to arrange that part of the trade. And that is part of the activity that the judge has found is taken place really using Nair and Walia in the DIFC. So one has the connection too. The next point on this topic is credit. My learned friend says, well, Sarasin entered into these trades into these credit trades as lender, as principal. And so it's excluded on that basis. Now, again, what he overlooks is there's also credit being provided by ABK, and whether and on what terms the ABK lending could be achieved depended on the arrangements for the IPO. And to that end, Bank Sarasin were in discussion with ABK to resolve the terms of the IPO and the basis on which the lending from ABK could go ahead, and then the products purchased from Sarasin. And those discussions were themselves conducted from the DIFC by Nair and Walia, and we saw an example of that in the document at bundle H1, tab 129. bad reference. And maybe another bad reference. It's a Tyrian document. Is it 129B? Well, 129A and B, in fact, both documents showing the discussion process between Nair and Tyrian in relation to the IPO and the terms on which the credit from ABK is going to be obtained. So again, there is an arranging function too. I don't want to take too much time on these points because, in a sense, this is not the biggest part of the case, but I do submit the judgment should be upheld on all points, including this one. So, clause 2.9.5 doesn't assist the learned friend in relation to arranging, and that was his big answer on arranging. Otherwise, we then go to arranging custody, and there's another similar technical objection by my learned friend, which is that Bank Saracen was not arranging custody, it was providing custody. And he's absolutely right to say Bank Saracen was providing custody. I can't argue with that. But this is not like, well, custody is something which you can be both an arranger and a provider. That's because you can be providing custody services, but you can also be arranging custody services. And here, D2 was also arranging because these were products which had a third-party custodian. So all these products were, all D2 actually had was an account. So when it talks about its custody and safekeeping of the investments, what that actually means is they're just booked to an account in Switzerland electronically. The actual custody, real custody, is with the custodian of the product, and that's not D2. D2 just has an account with the custodian.
And how is that custody by the third party constituted? Is it again another book entry?
Well, it depends, Lord. It depends on the product. And I would need to remind myself of what the underlying products were. For example, when one has notes, one has actually a global single note, which is then divided into sub-participations, and the sub-participations are traded. But an entity like Euroclear or Clearstream holds the note. Now, I think we've all traded and listed investments. There's a similar arrangement, but I'm not able to help you with exactly what the arrangement would be. Now, custody. The next question from my learned friend is, well, even if we're right on the global custodian or the other custodians, how does that have anything to do with the DIFC? And the answer is that obviously the custody follows from and goes hand in hand with the purchase of the investments, and the only negotiations and arranging that was done that the claimants had any awareness of was that done with the D1 personnel. And again, it all takes place from Switzerland, and indeed, even before confirmations of a trade are received. So when I say it all takes place from Switzerland, it all takes place from Dubai, even before confirmations of a trade are received in Switzerland, as I said, in relation to dealing with investments. Because the custody is part of the trade, custody is already being arranged, even before we get instructions received in Switzerland. My learned friend then sought to say he had a complete get-out to all of his claims because of Gen 2.3.2b1. Now, in fairness to my learned friend, he recognised that it wasn't his best point. He didn't drop it though, so I do need to deal with it. So it's Gen 2.3.2b1. This provides an exclusion where the person is a body corporate and carries on that activity solely as principal with or for body corporates which are within the same group as that person, or which are or are proposed to become participants of joint enterprise. And what he's saying